This is State of Idaho versus Bryan C. Kohberger. We have several motions set for today.
Your Honor, in our third motion to compel, we had a section called Standard Lab Discovery. They have provided full discovery for the sheet, the DNA found on the knife sheet, but not the other three.
Your Honor, we didn't realize this was going to be an issue today. We have given evidence, everything that we received from the lab. We can't do something that doesn't exist. They're hoping that there's something else there that's not there.
Welcome back to this special hour of coverage of the widower murder retrial. I'm Kelly Craft. Accused quadruple murderer Bryan Kohberger was back in court today. This was for a motions hearing ahead of his October trial. According to our producer in the courtroom, Anna Armez, Kohberger walked into the courtroom, half smiled at the jury, then he took a deep breath, and then the hearing began. The first witness to take the stand was Stephen Mercer. He's a criminal defense attorney who specializes in the use of DNA evidence. He testified about the impact and validity of the DNA evidence found in this case.
How did you become involved in this?
Yeah, so the question was, what would a reasonable defense attorney do when confronted with DNA evidence that needs to be litigated? What are the minimum practice standards? So I'm not here to discuss Idaho's discovery rules or offer legal opinions about constitutional standards. Rather, my area of focus is based on my experience, training, and expertise in forensic DNA litigation, and what a minimum practice standard would be for a reasonably competent trial attorney who must comply with their duty to investigate a case on behalf of their client.
And is that because of what you pick when you get genetic genealogy materials?
Well, yes. I mean, forensic evidence is often central in the case, and DNA evidence in particular. And so when there's an item, for example, here of an environmental sample of trace DNA evidence that, as I understand it from reviewing the pleadings, was twice tested, first for an STR profile and then later for a genomic profile. The question becomes, what is the minimum practice standard for an attorney to be effective in your representation of a client given that type of evidence?
When you're talking about two samples happen, there's two tests happening, why should an attorney know about that?
Well, there are a number of reasons why it's crucial for the attorney to investigate any testing of evidence that is central to a case. And again, here it's an environmental sample of trace DNA that is being tested. And so it's essential for the attorney to know, for a number of reasons, about the details of the testing and the investigation when we're talking specifically about forensic genealogy. Number one is there's pretrial concerns. And those pretrial concerns that can be raised would involve suppression issues and potentially Fourth Amendment issues. These are questions that are very much evolving in the state of our litigation. But to understand the viability of a Fourth Amendment challenge, there has to be a factual investigation. There has to be a determination of the conduct that law enforcement undertook during the forensic analysis of the genealogy. So, for example, was it fast and loose? Was there searching of data banks that violated the terms and conditions of those data banks? Was there surreptitious DNA collection from individuals, targeted individuals in family trees? So these are very fact-specific inquiries that the attorney must know in formulating a suppression challenge under the Fourth Amendment, because it's all about reasonable expectations of privacy. And what's really critical here to understand, and this is close to me from my litigation, early on, the government and law enforcement's argument was always there are minimal privacy interests at stake because forensic DNA profile is like a fingerprint, and it says nothing about who the person is.
All right, Court TV legal correspondent Chanley Painter. She was inside the courtroom. And Chanley, there has been so much going on here with these hearings today. She has a debrief now. Chanley, what do you have for us?
Thanks so much, Kelly. Yeah, what a day it has been inside the Slayton County Courthouse as we've been watching the defense fight by bringing their own expert witnesses in to try to convince this judge to issue an order compelling prosecutors to hand over everything related to the genealogy investigation that was taken under by the FBI in November after these murders happened to try to pinpoint a potential lead on a suspect. And we know that they were able to pinpoint the biological father of the alleged murderer, Bryan Kohberger's father. They then, of course, conducted a cheek swab after his arrest, and it was a match for the touch DNA on the knife sheath left at the crime scene November 13th of last year. So that's why all of this is so important to the defense, because they want to challenge every little step of this investigation. However, prosecutors are countering to the judge that this isn't relevant. This potential investigation that gave them a lead is not part of the case. They would not call any witnesses related to that investigation, and therefore under Idaho Rule 16 it would not qualify as part of the discovery. So the judge is going to have to make this decision at some point, possibly this afternoon. But inside the courtroom, I want to take you in there for what our cameras can't show, and that's the gallery. It is a pretty packed house inside the courtroom. We have media from all over the nation, community members here that we see almost at every hearing when this is before the judge, and we have the family of one of the victims, Kaylee Gonsalves, who earlier today walked inside this door right behind me, and they were solemn yet hopeful. The mother of Kaylee, Christy, told me that she was optimistic as they went into court today with their family attorney, Shannon Gray, and just wanting to make sure that justice is served, that the process of justice is unfolding, that they are informed of every aspect of this. We did notice that the t-shirt of one of the family members is advocating a hashtag justice for Kaylee and an Idaho bill that passed the firing squad as a potential penalty under the death penalty here as an alternate to lethal injection, and that's being worn, as you can see on the screen there, inside the courtroom during all of this unfolding. So a strong statement on what they feel from that family, which we knew because we have caught up with the family there, and they definitely are advocating for the death penalty. But that's why, according to the judge, these motions are so important, because this is a capital case. They want to make sure they cross all the T's and dot all the I's. And just, Kelly, coming up next, we are expecting, there's a short court break this afternoon, but we are expecting several more motions to be taken up. We're only on number 1 of 6. Will we run out of time? We don't know yet, but we do have another motion from the defense asking for a second stay in the proceedings. They want more of a delay without waiving the speedy trial right of the defendant. And then there's a handful of motions from the prosecution, including one about the alibi, demanding more specifics there. So a lot more to come today, hopefully, here in Moscow. But for now, I'll send it back to you.
All right, Chanley, thank you so much. All right, we do need to take a quick break, but we'll have more coverage of the Bryan Kohberger motions hearing, so keep it right here, your front row seat to justice.
Tonight on Closing Arguments, key takeaways from today's hearing in the Idaho college student murders case. Attorneys arguing several issues, including the defendant's alibi. Our experts are breaking down these motions and their impact on the upcoming trial. Plus, a Maryland mother of 5 found dead on a hiking trail the day after she was reported missing. We'll bring you the very latest developments in the investigation.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Welcome back to Court TV Live. We are continuing with our coverage of the Idaho College student murders case. Bryan Kohberger is charged with 4 counts of first-degree murder and a felony burglary charge in the deaths of Kaylee Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin. Key DNA evidence was found on a knife sheath at the crime scene. Police were able to tie it to a relative of Kohberger's, ultimately leading to his arrest. At today's hearing, we heard from a criminal defense attorney who specializes in the use of DNA evidence. He testified about the validity of the DNA evidence found in this case.
One produced a STR profile that I understand from the pleadings is represented as being a single source male profile. The reliability of that needs to be investigated, and certainly through one aspect of that is investigating the laboratory documentation that was provided for the STR testing. But we also have to appreciate, and again, I'm not a DNA scientist or a biologist, but I'm an attorney that works with experts, and I need to know what type of expert to hire. And one thing that I do realize in looking at this is when there's multiple tests of the same piece of evidence, and you have a genomic profile, in other words, potentially the entire human genome that is typed from this environmental sample trace DNA, or at least an SNP profile, which is somewhere in the neighborhood of 700,000 locations of data. What does that tell us about the STR profile markers? So for example, the STR profile markers, which are typed, are 20 out of 30,000 STR markers overall. And so what I would be investigating with a qualified expert is, number one, and I don't know from the pleadings if there's a whole genome profile that's been developed for the forensic genealogy, but if there is, that should contain STR markers. What does that tell us about the reliability of the STR testing? Is there any potential for artifacts? Is there any potential for an undetected low-level mixture? Those types of questions that are potentially available to inquire and ask about, where you have multiple tests of the same piece of evidence and it's an environmental sample of trace DNA. Now, if it's just an SNP profile, I say just, but that's 700,000 locations of information that is like a probabilistic future diary of someone's health, medical, and all manner of conditions that are linked to genetics. That may not have the STR markers in it itself, but it will have information, SNP markers in the neighborhood of, so to speak, of STR markers that will also shed light potentially on those STR markers and the reliability of those STR markers. So these are, particularly in a capital case, crucial areas of inquiry that must be undertaken by the defense team in conjunction with experts that they retain. But they can't even decide what experts to retain without having the discovery. And that's the minimum practice standard. And that's a point that I've made in testimony before courts where I've been accepted as an expert in Maryland, DC, and Virginia, that the minimum practice standard is that the attorney must obtain discovery of the scientific testing of an evidence sample. And that, particularly so in a capital case, particularly where we're talking about an environmental sample of trace DNA, is absolutely crucial to get that discovery, because then that informs the scope of the investigation, the experts to hire, and what have you. Now, also with respect to the forensic genealogy, it's important not to separate this out into all these different components. It is, you have the SNP testing, and then you also have the development of these family trees through database searching. This is all part of the same testing and experiment. They go really hand in hand, and you can't unravel them. They really have to be considered together as a single cord of different strands of the testing and experiment, because the attorney needs to know how these family trees have been developed, because we're talking now about trial issues. and the government is introducing the STR profile, they have to introduce statistics that explain the significance of any STR match that the government is identifying as central to its case. And so the defense must investigate ways to cross-examine those statistics and the rarity of that match that the government is attaching great significance to. And so an area to look into and to inquire about are the limits of the statistical tool that the government is using or the state is using, which is based on the premise that sort of what's called the random person not excluded. And that's answering the question of the rarity of a profile in a population of unrelated people. But the key point there is unrelated. So we know there's no universe where a STR profile has no relatives. And in fact, in a case involving forensic genealogy, the way that the defendant is identified is by searching a pool of related people.
All right, we do want to bring in one of our experts here to discuss what's been taking place all day throughout these hearings. We have trial and civil attorney Dante Mills. Hi, Dante. Thank you so much for joining us tonight. So, Dante, we're listening to Stephen Mercer. He's a criminal defense attorney and specializes in DNA analysis. And one of the things that he is talking about there, I mean, that's a challenge for the defense when you can't even determine what experts that you're going to want to use to put on your case because you don't have all of the information. What do you think?
Well, let me tell you, DNA evidence has a lot of holes in it. And as of right now, from what we know, this knife sheath with DNA was the only thing that ties Kohberger to these killings. That's the only thing that places him at the scene. And when you want to prove murder, you have to show that the defendant was actually there where the murders happened. So, of course, the defense is going to attack this DNA connection because from what we know, that's the only connection. And DNA has problems. The first problem is it can't tell time. So it can't say when the DNA got on that knife sheath or when was the last time he touched it, if in fact he did. The second issue is with DNA, it doesn't connect someone directly. It just rules out other people. So it says that he could be a potential match. And what the defense is saying is, what test did you use to determine the factors that matched him? Because remember, there's an additional layer. They initially determined that it matched his father because of DNA that his father submitted through one of those programs like Ancestry.com. And then once they saw that it was a match with his father, they saw that it was a match with a relative of his father, which is Kohberger, would have been his father's son. So we have a separate connection on the DNA. It's not a direct match to Kohberger. It's a match to his father, and then shows that it could match his relative. So the defense is saying, show us how that match was made. If you can't show us how you made that match, you shouldn't be able to use this DNA. And if they can't use that DNA, that's a big problem for the prosecution.
It's a huge problem for the prosecution. I mean, Dante, you made some excellent points here. I mean, talking about DNA can't tell time. There have been reports that this house where the 4 victims were and lived, that it was a big party house. A lot of people would go there all the time. So who knows when that DNA could have gotten on that knife sheath? I mean, I don't know. There seems to be a lot of problems.
It is. And one other thing with DNA, there's 2 types that you can have. You can have direct DNA or transfer DNA. So if you talk about this being a party house, if someone who came into contact with Kohberger either sat in his car or maybe went to his house, then went to that party, they could have transferred his DNA to that sheath. There's no way to know that. There's no way to know if someone touches something directly or if something they touched is touched by someone else, and then that someone else touches it and transfers their DNA onto it. So I'm telling you, we got to watch out for this. DNA is not a lock. I've beaten a lot of cases as a criminal defense attorney where DNA was the only connection to the defendant and the crime scene because there's a lot of holes. You generally need other things, and then that DNA is the icing on the cake. They say, oh, somebody saw him there, or somebody witnessed him walking in or out, and we have his DNA. There's no other connection right now. We only have the DNA. So, it may be a problem.
All right, Dante, thank you so much. We are going to quickly take a break here, and then we're going to come back. We're going to have more coverage of the motions hearing in the Idaho College murders case, so don't go anywhere. You are watching Court TV, your front row seat to justice.
Tonight on Closing Arguments, key takeaways from today's hearing in the Idaho College student murders case. Attorneys arguing several issues, including the defendant's alibi. Our experts are breaking down these motions and their impact on the upcoming trial. Plus, a Maryland mother of 5 found dead on a hiking trail the day after she was reported missing. We'll bring you the very latest developments in the investigation.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Welcome back to Court TV Live. I'm Kelly Craft. A motions hearing is continuing in the Idaho student murders case. Bryan Kohberger is accused in the brutal stabbing deaths of 4 University of Idaho students. Attorney and DNA consultant Bikro Barlow is now on the stand. And we want to let you know that the static sound, you might hear that's coming from the courtroom. It's a fan in the background. So if you hear it, it's a fan. We want to get you back into court.
I want to focus a little bit on one of the areas of discovery and why it's important to have an area of discovery. I want to talk about DNA profiles and what happens. In our case, there are 3 other unidentified male profiles. What are we missing?
Well, I believe at this moment we have all of the reports of the testing from Idaho State-based laboratory. What I believe was requested and what has not been produced is any direct information or documentation of whether those profiles were uploaded to state or federal offender or CODIS database.
I want to talk a little bit about the CODIS database. You said federal or state.
Well, yes.
50+1.
Every state has their own state-level CODIS system that's essentially operated through software that's provided by the FBI, I believe, Federal Department of Justice. And each state has its own statutory scheme regarding what can be uploaded, what can't be, and what types of records should be in there. I'm very familiar with California's law. I'm not so familiar with other state law on that issue. And each local crime lab has a called LSEIS. It's their local level database that they can upload things that are not even part of the state system, but that feed into the state system. And then the state level databases feed into the federal database, but because there are different federal rules and statutes around what can be uploaded, not everything that's in every state database goes to the federal system. So there may be more in Idaho than Idaho actually puts up into the federal database.
Why would we want that? Why would we want to know if those other 3 unidentified male profiles have been entered into the
I'm going to object. I believe we resolved this portion of the discovery proceeding this morning. That was my understanding. I'm not sure we're rehashing the particulars witness.
Where I don't think we resolved it. I don't think we have everything. I don't have an answer from the state saying we didn't upload those 3 profiles anywhere. We did nothing. If that's the answer, then I mean...
That was the answer. Is that the answer?
I thought that had been communicated, and I thought that the lab personnel had communicated that those samples are not eligible to be uploaded to CODIS. It is my understanding that has been communicated to Ms. Counsel.
So you have been told that it wasn't uploaded, so there's no.
Correct.
That wasn't pursued.
Yeah, the samples did not meet the criteria for uploading to CODIS. That's my understanding. And I believe Ms. Jennings is the one who communicated that to Ms. Taylor. She's looking at it.
Your Honor, if the answer is that they absolutely have not been uploaded to CODIS, then that's the answer.
That's what
I heard it now. I heard it now.
Great.
I'm not sure I'm real comfortable with leaving it that way because she heard it before. This isn't a surprise, Judge, and I think it's unfair to characterize it that way.
Well, let's just get past it.
Yes, sir. Fair to do that.
If that's resolved that way, then that's resolved that way. I think it's satisfied. So let's sustain the because it's been answered.
All right, maybe just a moment so I can pass that way. Ms. Barlow, one of the other areas is whether or not we have corrective action or irregular result reports.
Your Honor, I'm going to object. The state indicated this morning that we would reach out to the lab, that we had disclosed everything in our possession, that we will reach out to the lab. I do not think it is appropriate for counsel to call an expert witness as an attorney to discuss and relitigate a discovery dispute that was addressed this morning. It's not an appropriate thing for a fact witness to testify about, Your Honor.
Well, yes, Your Honor, and these are things that have been in the defendant's third motion to compel for quite some time now. And I do know we have some of those results. We don't have the full scope of them. I understand the state says they'll reach out now, but I mean, we're months into this. I think maybe it might be helpful if the court understood why we want those, why they're.
Okay, I'll overrule that, and just to get some understanding why that is important, even though the state has already said that they're going to provide that beauty in that area. So,
Ms. Barlow, we requested 6 months before and 6 months after the date of the incident. Why did we want that scope of corrective action or irregular results?
Well, I think it sort of, just to preface your question, the corrective action logs are part of the lab's quality system. So it's part of what they use to determine whether their quality systems are working. It's a way to track things like contamination events. It's a way to track things such as sample switching. It's a way to track the presence of unknown contaminants that appear in the laboratory. And it allows the laboratory to assess whether or not their own methodologies are working the way they're supposed to be. And one of the most important aspects of crime lab work is to not contaminate your samples, obviously. And so many laboratories now have to maintain these as part of their accreditation standards. And once a corrective action is noticed, somebody identifies a contaminant in a sample, for instance, the lab then goes through and does what's called a root cause analysis. So they will go back and look at whether a particular analyst has a particular habit that caused the contamination. They will look at things like whether some of their chemicals or reagents are contaminated, and that's what they're seeing. And they have to document that as part of the accreditation process. And so what it allows people like myself to do is to actually assess the overall quality, and it helps a jury understand the overall quality of the work that's being done in the laboratory itself, and whether the lab is following the protocols, and whether it lives up to the promise of the protocols to be demonstrated and reliable and accurate results.
Thank you. So let's get ahead in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit. 1 of the things that I had in my notes a little bit
Yes, I've consulted on at least 3 of these, and then this one.
And the information contained in the genetic genealogy, I guess, testing and then the creating the trees, is that something that is utilized to make decisions in a defense case?
Yes. And I guess the reason I hesitate there is because this is a brand new technology that's just been introduced to the court system. And there has not been a lot of litigation in this area. There's not been a lot of testing in this area in the sense of cross-examination, which I think is how most of these methods are tested in the crucible of the courtroom, essentially. And most of the issues that we find with DNA testing in the past, or that I have found in my career, I'm aware of through engaging with other lawyers and scientists around the country, is that most of these things are found out through the discovery process. In other words, we get the information so we can do our own investigation. And I have in my mind exactly what I would do with this if I were in that position.
Sure. Please, Harlan, thank you. I don't have any other questions, but hold on just a minute.
Oh.
Thank you. Any cross-examination?
No, thank you.
All right. Thank you. May I just excuse me?
Yes.
All right. Marla?
Okay, that concludes her testimony there. We do need to get in a short break here, and when we come back, more coverage of the Bryan Kohberger motions hearing. Keep it here for your front row seat to justice.
Tonight on Closing Arguments, key takeaways from today's hearing in the Idaho college student murders case. Our experts are breaking down these motions and their impact on the upcoming trial.
Closing Arguments coming up next, only on Court TV.
These are the cases that captivated the world.
Couldn't keep my life straight.
They were killed by their own children.
Court TV Legendary Trials. Go to courttv.com/legendary trials to find out how to watch.
And welcome back to Court TV Live. I'm Kelly Craft. We want to toss back into court because the attorneys are getting ready to do their argument. So let's take a listen.
It allows us to make decisions about how we might cross-examine this evidence, how we're going to confront this evidence. And he also made it crystal clear to you that it is scientific evidence because we began with a surface trace sample that has been extracted to DNA. A portion of that DNA went to an STR test, and a portion of that test went to some other lab that we really don't yet know. There's been discussion in pleadings about whether or not it's Othram Lab or some other lab. I think kind of the general knowledge is that it's Othram, but we really don't even know that. So this original scientific sample from this surface trace DNA has been the product of multiple scientific experiments that we are entitled to have the underlying data on. And if we don't have that information, we are not going to be able to be effective attorneys for Mr. Kohberger. We then were educated by Dr. Larkin, and it was helpful to really understand what is this genetic genealogy and what's going on. And one of the first questions that the court asked as we began today was, if we have a sample and we have a buccal swab, why is all of this other material that you're asking for related to the genetic genealogy so important? And the first, the second, the third, and the fourth witnesses really all set that up. But in particular, Dr. Larkin explained to you that in that process, there are so many human decisions that are being made about the ultimate SNP sample that that was used to take further action. Some of those human decisions are what type of test was run. We don't know if it was a whole genome sequencing or if it was this next generation sequencing. That's something that's not being disclosed to us. Whole genome sequencing has a whole set of information that we may be able to look at and see if our STR sample that the state is relying on is indeed reliable, or if there are contamination issues, or if there are mixture issues. Next generation sequencing, if that was the method, has bioidentifying information that was used, decisions that were made by human beings about what to include in gaps, what to strip out in gaps, and how to create the S&P sample that was then uploaded. Another critical piece of information that you learned today, Judge, is that law enforcement may or may not have used databases that they had the right to access. We don't know. We don't know what databases they uploaded to. We don't have the raw data to know if they accessed people that had opted out of the databases that they are allowed in, and we don't know if they uploaded information to MyHeritage. If we have that raw data, we will be able to make that determination. It could be that nothing is amiss, but certainly when we're having to fight this hard to get this information, it makes us quite suspect, especially when you've got a witness like Ms. Vargas with her experience who's saying, this happens in the industry and I know because I work for law enforcement. And every single person in this courtroom should have pause when we are talking about forensic science that is no more than 5 years old. We know through the course of time with forensic science that there are all kinds of problems that arise when we rely on it. Teeth marks are a key example of where, years ago that was reliable science, and now it's been determined that it's absolutely not reliable science. We are dealing with something that is brand new and with all kinds of possible mistakes that could be made, and it's also possible that things that it could have been completely appropriate. And finally, when it comes to Ms. Barlow, I think what you see, and what also you heard from Mr. Mercer, is this intersection between the science side and the legal side, and everything that our team is having to do with that, and the state as well. We've got to understand it. We've got to have the raw data to know what we need to do with that. And then we've got to figure out if we have defenses that we need to raise for Mr. Kohberger. So individually, each of these experts gave you the information that you needed to order a motion to compel on the genealogy information that we've asked for. Cumulatively, it is overwhelming that we must have this evidence to do our work. Thank you.
Let me, I just want to make sure I understand this. So you have all the information from the labs and all that as regarding the STR. Is that right?
Well, Judge, with the exception of all of the emails, which was one of the things that we were having some discussion about. So we have some emails that we can tell there were other emails attached that weren't, or attachments that are not there, and we have blank pages. And so the solution to that is simply order it. And then they'll take that to the Idaho State Lab and the FBI lab that's been involved, and tell them that we need it all, and then we'll have it.
If it exists. We've had a couple of arguments about that already.
If it exists, and I'm not willing to concede that it doesn't, Judge.
And I understand that. I understand you're asking that. And I'll have some questions for the state too, because they're arguing that it doesn't. Whatever happened with the genealogy DNA doesn't have much bearing, has no bearing on the case.
Oh, well, right. That's their whole argument, that That's why you had 4 witnesses today to explain why that is so critical. So that's a different argument than whether or not we have all of the Idaho State Lab and FBI Lab STR emails and the emails that discuss genetic genealogy. Because we understand that they've said you shouldn't get anything related to genetic genealogy. But what we're also telling you is that we don't believe that we have all of the emails related to all of the DNA evidence related to STR. And if you enter an order, then the labs that are involved, it'll be clear to them that they've got to produce that.
You're suggesting, hey, it might be just fine. But you need to examine that to determine that it was just fine.
Are you talking about the genetic genealogy?
Yes.
There's the possibility of both. Honestly, I don't believe that it probably is just fine, Judge. If you're really asking, if we're having to fight so hard for this, and we have someone who's just testified who has worked for law enforcement that improper searches have been done. So I can make the assumption that it was done correctly. I can make the assumption that it wasn't done correctly. If it was done correctly, we probably wouldn't be fighting this hard about it. That's my assumption.
Right. Well, right. They're a little bit suspicious about it.
Absolutely.
Why don't we get all this? But let's just say, for the sake of discussion, that FBI went around the rules. Does it have any impact?
It does. It does for a variety of reasons. It's going to have an impact on the method of cross-examination. As a preliminary matter, it's probably going to result in a motion to suppress based on an improper search and privacy rights. So we're going to have pre-trial litigation.
Whose rights would be violated there?
Mr. Kohberger's rights. But Judge, we can't make a decision about who until we know what the raw data is and what it says.
Sure.
Right?
Well, I don't want to get into it.
Dante, I want to bring you in really quickly. We're listening to the arguments made. I mean, talking about sample switching, contamination, privacy. Defense counsel is saying we need information or we cannot effectively represent our client. I mean, it's a valid argument.
Yes, and there's big picture, let's go. There's 2 things when evidence comes in. It has to be reliable and it has to be gathered in a legal way. What they're saying is we don't know if it's reliable because we don't know the background testing and how they got this sample. And we also don't know if it was gathered in a legal way because the police may have checked databases that they shouldn't have access to. And if either of those are true, then that DNA should come out.
Yeah, I mean, the judge just said, let's just pretend the FBI did go around the rules. What kind of impact would that have? And then the attorney just said, yeah, we're going to do a motion to suppress, improper search, privacy. I mean, this is a big deal.
Yes. You always hear that the phrase is fruit of the poisonous tree. Exactly. Once someone does something illegal, everything that came after that. So if they looked in these databases and they weren't supposed to, whatever evidence they got from that search is out. Anything that comes after that illegal motion is gone. And so that could impact the DNA evidence.
What do you think the judge is going to do?
There's a lot missing here from what I'm hearing in her argument. There's a lot missing. Some of the research, the initial tests that were done, I don't know if you can truly authenticate this evidence. So the judge is really going to have to push the prosecution to say, what did you use? And if they can't show that, then he may have no choice but to throw it out.
We're going to have to see. All right, Dante, thank you so much for joining us tonight. Great insight. I really appreciate you staying around and giving us your thoughts on this.